Hi, everybody. This is going to be the case PAK Foods Houston LLC versus Garcia. Again, we're still looking at contractual capacity and minors entering contracts. In this one, you've got a 15-year-old female minor. She worked at a KFC restaurant that was operated by PAK Foods in Houston. PAK Foods had a policy that in order to resolve any dispute with an employee, they were required to go through arbitration. Now, we covered arbitration and mediation in a previous chapter. Arbitration is different than mediation. In mediation, you can go in with your attorney, the other party comes in with theirs, you sit at a meeting and you try to resolve something, and there is a third party, usually an attorney there, who will help you try to resolve the issue, come to a conclusion. You can walk out of mediation without having resolved it, and you don't give up your right to go to court. In arbitration, it's the same setup, but you agree to whatever the third party attorney or mediator or arbitrator says, and then you do give up your right to go to court. So when SL was initially employed, she was required to sign this acknowledgement of this policy. Okay, so that could happen to any of you. So first of all, do you think that that would be a valid contract based on what you already know about minors and contracts? Is she bound to this? So she gets injured on the job, and as a result, she terminates her employment. So SL's mom, her name is Marissa Garcia, filed a lawsuit on behalf of her daughter in a Texas state court, so this case was held in Texas, to recover for her medical expenses for the injury. And PAK Foods files a motion to compel arbitration. They don't want it to go to court. They want to require her to come in and talk about it through arbitration. So the court denied the motion. To the extent any agreement to arbitrate existed between SL and PAK Foods Houston, she voided it by filing the lawsuit. Okay, so that's what the judge originally said. So anytime you file a lawsuit, it's kind of saying, I'm not going to follow that. Now, other people can't do that but this was a minor that signed that. So PAK Foods appealed this. And here are their key points. They argued that SL was an at-will employee and did not execute an employment contract. It was an agreement. They also argued that she did not notify PAK Foods prior to filing a lawsuit that she was voiding the arbitration agreement. They think she needed to file something before that. Garcia's points, so her mom's points, that she voided the agreement by terminating her employment and filing a lawsuit. The mere filing of a suit doesn't necessarily disaffirm an arbitration agreement. Okay, so a party can file a lawsuit, but later determine that they want to go into arbitration. However, although the first petition by Garcia did not expressly disaffirm an agreement to arbitrate, her response filing in opposition to the motion to compel arbitration is definitely a demonstration that she is disaffirming the agreement to arbitrate. Kind of confusing, right? But so they're saying her initial filing didn't demonstrate it, but when they were trying to get her to force her to go into arbitration and she denied that, she fought that, that was definitely a sign that she did not want to arbitrate. So since SL was a minor at the time of her employment, arbitration agreements are voidable at her instance, because she's the minor, and they can be disaffirmed or repudiated by her guardian. So minors can disaffirm a contract at their option. Garcia was allowed to file suit against PAK Foods. So good question. Could PAK Foods successfully contend that SL's minority does not bar enforcement of the arbitration agreement because medical expenses are necessaries? Because remember, minors are held to all contracts regarding necessaries. The court doesn't address that. It's just food for thought going down the road, and it would have to actually go into a court proceeding to find that out. Have a good day.